Welcome back to the Constitutional Clarion, coming to you from Oxford. I hope you're enjoying my Whitlam dismissal series. There's more of it to come, with a very special one for the 11th of November, coming from a particularly pertinent location. But I'm interrupting the flow of that series with a quick contemporary video on the challenge by James Cullen, the New South Wales Premier's Chief of Staff, to the constitutional validity of Section 8 of the New South Wales Parliamentary Evidence Act 1901. Now, I've previewed this before when a number of ministerial staffers were summoned to appear before the New South Wales Legislative Council's inquiry into the Dural caravan incident. For an overview of the various issues, please go back to look at that video. Subsequent to that video being made, the staffers, in the face of threatened arrest warrants, chose to appear voluntarily before the committee. As Shakespeare would have put it, this resulted in sound and fury, signifying nothing. This time, however, the Premier's Chief of Staff has chosen not to appear before a different Legislative Council committee hearing concerning an alleged leak of privileged material concerning a parliamentary committee inquiry related to the proposal to sell the Rosehill racecourse. He has instead chosen to commence legal proceedings, presumably against the President of the Legislative Council, challenging the validity of at least one section of the New South Wales Parliamentary Evidence Act. Now, I haven't seen the legal documents, so in this video, I'm just guessing about what the issues will be. On that basis, I'll discuss two aspects of the potential case. One concerns the history of the coercive provisions in the New South Wales Parliamentary Evidence Act and how they are intended to connect with the law and custom of Parliament. The second is the constitutional issue concerning the separation of powers and the institutional integrity of the courts. The Houses of the New South Wales Parliament do not have an inherent power to compel witnesses to give evidence to them. Now, this was determined by the Privy Council in a case long ago called Fenton and Hampton from 1858, which held that it was not necessary for the operation of the Legislative Council of what was then known as Van Diemen's Land, now Tasmania, that it have the power to compel external witnesses to give evidence to it and to produce documents. While the Houses of the United Kingdom Parliament, having originally been courts, had a power to punish for contempt, this was not transferred to the colonial legislatures, as it had, quote, the potential to work as an infringement of the liberties of the subject, unquote. In more recent times, Justice Kirby pointed out in the case of Egan and Willis in 1998 that without valid legislation, a House of the New South Wales Parliament does not have the power to punish for contempt. Justice McHugh added that it was plain that in the absence of the statutory power contained in the Parliamentary Evidence Act, that the Legislative Council of New South Wales could not compel non-members to attend before it. The validity of the provisions of the Act is therefore critical to the exercise of the powers of the Houses over members of the public, including public servants and ministerial staff who are asked to give evidence before the Houses or their committees. It's also important that this Act accommodate the law and custom of Parliament itself, including the privileges of the Houses and what's known as the exclusive cognizance of each House over its members and proceedings. For this reason, Section 5 of the Parliamentary Evidence Act recognises that one House cannot compel a member of the other House to give evidence before it. The Act instead relies on the conventions developed in the United Kingdom over centuries that a member of the other House can only be requested to attend. To satisfy the principle of responsible government, ministers in one House are represented by other ministers in the other House so that they can be questioned there. As occurred in Egan and Willis, a minister can also be suspended by the House of which they are a member if they fail to comply with a valid order of the House. This accommodation of the law and practice of Parliament is also reflected in Section 7 of the Parliamentary Evidence Act, which only allows the presiding officer, the Speaker or the President, of a House to certify a matter to a judge for a warrant for a witness's arrest if the failure of the witness to attend when summoned is, quote, without just cause or reasonable excuse, unquote. The Speaker or President is intended to respect and uphold the conventions of parliamentary privilege and the proper relations of the Houses in exercising his or her assessment of what is a just cause or reasonable excuse. This was recognised by Chief Justice Gleeson in Egan and Willis in 1996, where he observed that unresolved questions affect the exercise of the power to compel witnesses, including the role of the conventions and courtesies observed in relations between the two houses in a bicameral legislature. According to Chief Justice Gleeson, the powers of the houses are, quote, exercised in a context in which conventions and political practices are as important as the rule of law, unquote. He observed that these conventions and courtesies are not likely to be disregarded and are an important aspect of our constitutional arrangements. So the Parliamentary Evidence Act needs to be read in that context. Its history is also helpful. The qualification of just cause or reasonable excuse was first introduced into the earlier Parliamentary Evidence Act. That was the Act of 1881. And this was done after a number of efforts to pass a Parliamentary Privileges Bill had failed. That failure was in part due to public concern about provisions that would permit a House to imprison non-members for contempt committed outside Parliament. As one Member of Parliament, Mr. Daly, put it, this was opposed by those who under no circumstances would consent to sacrificing the liberty of the people to the alleged necessity of maintaining the dignity of Parliament. The Parliamentary Evidence Bill, back in 1880, as introduced, did not contain any provision about warrants and arrest. Instead, there was to be a pecuniary penalty for failure to attend a hearing when summoned. George Read, however, objected that a witness might prefer to pay the fine rather than give evidence, and said that the Houses should have the same power as the courts to deal with the non-attendance of witnesses. The Legislative Council then introduced such an amendment, which was later accepted by the Legislative Assembly. The phrase just cause or reasonable excuse was then drawn from existing evidence laws and can be traced back to Section 13 of the Law of Evidence Act 1858 of New South Wales. Section 13 of that Act provided that the court could issue a warrant to bring a witness before the court upon proof that the witness had been served with a subpoena to attend and failed to do so, and that his non-appearance was without just cause or reasonable excuse. It was also necessary to claim under oath that the witness would be able, probably, to give material evidence in the case. Now, that's important for two reasons. First, there needed to be proof that the non-appearance of the witness was without just cause or reasonable excuse. And that remains the case today under Section 194(1) of the Evidence Act 1995, New South Wales. The onus is on the party seeking the warrant to satisfy the judge that the witness has no just cause or reasonable excuse. It remains a subject of uncertainty, however, as to whether that must be established beyond reasonable doubt or on the balance of probabilities. The evidence which the witness could give also had to be material to the case. In contrast, Section 7 of the Parliamentary Evidence Act 1901 uses the term satisfaction rather than proof. The President or Speaker must be satisfied that the failure of the witnesses to attend is without just cause or reasonable excuse. Nonetheless, as the provision was intended to reflect that in the Evidence Act, it does suggest that there is a high hurdle to reach that level of satisfaction. Only then can the facts be certified and sent to a judge of the Supreme Court for the issue of an arrest warrant. The other problem, of course, is that under the Evidence Act, it's a court that makes a judicial decision about the issue of a warrant with all the protections of judicial independence and fairness and natural justice. It's the court that also makes the assessment of whether the non-appearance of a witness was without just cause or reasonable excuse. It's far more problematic when it's a politician making such an assessment, especially when party politics may come into play. Now, this brings us to Section 8 of the Parliamentary Evidence Act. It provides that upon the presiding officer issuing a certificate to a Supreme Court judge, the judge shall issue a warrant in the form set out in Schedule 3, quote, for the apprehension of the person named in the certificate for the purpose of bringing the person before the council, assembly or committee to give evidence, unquote. There doesn't appear to be any exercise of judicial discretion involved. The judge does not get to assess whether there was just cause or reasonable excuse, or indeed any other reason why the issue of the warrant is not appropriate. The judge is effectively no more than a rubber stamp. There's a significant constitutional argument that a judge, if compelled to issue a warrant without the exercise of any judicial discretion, would be acting in a manner that is incompatible with the institutional integrity of the Supreme Court. While the separation of powers does not formally apply at the state level in Australia, the High Court has developed a line of authority which requires those state courts which can exercise federal jurisdiction, which of course includes Supreme Courts, to exhibit institutional integrity and decisional independence. This is also extended to judges acting as what's called persona designata, which means that they're exercising a power in their individual capacity rather than as a court. One strand of this principle, which was developed by the High Court in the case of Cable and the Director of Public Prosecutions in 1996, was actually picked up from the 1989 US Supreme Court case of Mistretta and the United States. The US Supreme Court stressed the importance of the reputation of the judicial branch for impartiality and non-partisanship. It then said, quote, that reputation may not be borrowed by the political branches to cloak their work in the neutral colours of judicial action, unquote. It's this cloaking doctrine which expressly applied to both political branches, the legislative and the executive branches, which the High Court has applied in many cases since then. The last time this issue arose in relation to the Dural Caravan inquiry, the Legislative Council obtained a legal opinion which said in paragraph 30 that this doctrine does not apply to the issue of the warrant because the Legislative Council is not the executive. Well, it's not, as we all know, but the High Court has referred on many occasions to this cloaking doctrine as applying to, quote, the political branches, unquote, in the plural, and to the cloaking of the work of the legislature or executive in the neutral colours of judicial action. And it did so in a number of cases. So what have we got? We've got Cable, Grollo, Wilson, Farden, Gypsy Jokers, Lane, Tatani, Kazborski, Vella, Garlett, and I've run out of fingers. So, for example, in Vella and the Commissioner of Police in 2019, Justice Gageler observed that the independence of the judiciary is more likely to be destroyed by the creeping normalisation of piecemeal borrowing of judicial services to do the work of the legislature or the executive than by any single act of outright conscription. The anti-cloaking principle clearly extends to the legislature, and the legislature is comprised of the monarch and the two houses, including the Legislative Council. Any assertion that this principle does not apply to the Legislative Council because it's not the executive runs contrary to both existing High Court statements and constitutional principle. True it is that the High Court has not yet had the opportunity to directly apply the anti-cloaking doctrine to the actions of a House of Parliament. But this can be easily explained by the fact that the Houses, consistent with the principle of ministerial responsibility, do not normally seek arrest warrants for ministerial advisors. It's the relevant minister or his or her ministerial representative in the other House that is subject to the House's questions and examination, and potentially its discipline. This position is well known and accepted by Houses of Parliament across Australia and is known as the McMullen Principle. If this Cullen case proceeds, we might get some judicial authority about how the Parliamentary Evidence Act is to be interpreted in the light of the law, practice and conventions of Parliament, and on whether the anti-cloaking doctrine will apply to invalidate the coercive provisions under the Parliamentary Evidence Act for the arrest and detention of witnesses who decline to give evidence upon summons by a parliamentary committee. Now, for those who are interested in Parliament and the Constitution, as I am, it will be a most interesting case. Thank you for watching the Constitutional Clarion, and I will return to those dismissal videos shortly. See you then. Goodbye.